case briefs, and so much more. LSData's got what you're looking for.
Carson Harbor Village, Limited filed a lawsuit seeking reimbursement for costs incurred while cleaning up a contaminated wetlands site that was previously used for petroleum production and later as a mobile home park. The defendants, the Carson Harbor Village Mobile Home Park, Richard G. Braley, and Walker Smith Jr., were sued as potentially responsible parties, PRPs, under the Comprehensive Environmental Response, Compensation and Liability Act, CERCLA. The case focused on whether the cleanup costs were necessary and whether the defendants are PRPs under the law. Carson Harbor Village appealed the district court's original decision, arguing that the migration of contaminants on the property should count as disposal under CERCLA and that they had proven a genuine threat to human health or the environment. The United States Court of Appeals for the Ninth Circuit reviewed the case in 2000. The court determined that the district court made an error, ruling that the partnership defendants were not PRPs due to no intentional disposal. Carson Harbor Village needed to raise a genuine issue for indemnity claim survival. The court reversed and affirmed various summary judgment grants, with partnership defendants potentially liable for damages and costs in 1983 property cleanup.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.